Tolua.
Tolu Akimayowa.
Okay, Moyowa. Is who today? Is it chairman or secretary?
And the legal officer.
Okay, legal officer.
Yes, my lord.
Then the second defendant, Mr. Odum.
He's absent. He's absent. Apologize for the absence.
It's okay. Yes, so Lateral Prof.
My lord, sir.
Yes.
I represent the claimant, sir.
Yes. Oladipo.
Professor Oladipo O. Solanke, sir.
Solanke. Yes, for the
claimant, sir. Yes, sir.
Yes, thank you. Yes, Abdul.
I also have my learned colleagues with me, sir.
Okay, still love it.
Lovett Patrick.
Okay.
And Ola Osebikon Ajibola, sir.
Ola
Osebikon Ajibola.
Okay.
Okay, it's a long name.
Yes. I just said Ajibola.
Yes, sir. Yes, sir. Thank you very much, sir.
Thank you.
Respectful, may my lord be pleased. Abdullah Omoloye. I appeal for the.
You're alone?
Yes, my lord, I'm alone.
Okay.
I don't want to delve into the prof's jurisdiction.
Okay, is Mr. Odum. Is Mr. Odum. Okay, we've lost him.
He's been around since, maybe it's network issue, sir.
Yes. We have lost him, but can we just move on, Prof?
Yes, sir.
Okay.
As the court pleases, sir.
As the court pleases, I believe he's here with us in spirit. Probably it's the network that has.
Okay.
It's limited time for this session.
So this is my judgment. Yes, the claimant commenced this suit by a complaint and other accompanying processes filed on the 18th of June 2022 and asked for the following reliefs as contained in the statement of fact against the defendant. Number one, a declaration that the picketing action or any other industrial action planned, intended, or threatened against the claimant by the first defendant or any person or persons acting on its instructions is unlawful, unjustified, and unwarranted. Number two, an order of perpetual injunction restraining the defendant's agent, previous, or any person acting on their instruction from embarking on or carrying out any picketing activity or any other labor activities against the claimant or any of its business premises in the country. Upon service of the registration process on the defendants, the first defendant entered conditional appearance on 15th of July 2021, but filed a statement of defense and counterclaim via an application for extension of time to that effect. The first defendant counterclaim asks for the following reliefs. Number one, a declaration that by virtue of clause 9.2.4, the transaction implementation agreement dated at 1st December 2013, the claimant/defendant counterclaim is unconditionally obligated to pay all outstanding staff liabilities of the second defendant. Number two, an order of this honorable court directing the claimant/defendant to counterclaim to pay all outstanding staff liability of the second defendant, including gratuity, pensions, redundancy benefits, and other terminal benefits, and entitlement in line with ITA and the second defendant's staff policy guideline of July 2007. Number three, cost of this action. Similarly, the second defendant filed a memorandum of appearance on the 9th of July 2021, but filed a statement of defense and other defense processes via leave of court granted on 28th of September 2021. The claimant thereafter filed a defense to the first defendant's counterclaim via leave of court granted on the 7th of December 2021. Case of the claimant. The case of the claimant is that by transaction implementation agreement, TIA, dated 31st of September 2013, and executed between the claimant, the second defendant, ASO Savings Salons PLC, and UHI Nigeria Limited, the parties to the agreement agreed on a framework for the acquisition of a second defendant by ASO Savings Salons PLC. By clause 9.2.4 of the state ITA, the claimant undertook to create credit line for settling staff liabilities of the second defendant as of 31st January 2014. That prior to the execution of the TIA, the claimant had paid the sum of 9.9 billion naira in short-term deposits or to various customers of the second defendant, on behalf of the second defendant, on the agreement and understanding that the payment will be recovered from the second defendant. It was also averred by the claimant that some ex-staff, the second defendant, following their exits, it's like some persons are not muted, please. It was also averred by the claimant that some ex-staff of the second defendant, following their exit, commenced a legal action against the second defendant for the payment of their outstanding severance benefits, and this court on 2nd of July 2015 delivered a judgment and directed that the second defendant pay the ex-staff outstanding terminal redundancy benefits along the provisions of staff policy guidelines of the second defendant. The second defendant thereafter, sorry, there is a lady disturbing us, please. Hello.
Hello. Don't disturb this again.
Yes, there's a Nokia C1 disturbing us.
Yes, Nokia C1. Please, can you mute yourself? Madam, the person having Nokia C1. Person having Nokia C1. The second defendant thereafter made a demand on the claimant of the outstanding staff entitlements along with the claimant's obligation under clause 9.2.4 of the TIA. However, according to the claimant, that since the second defendant was owing the claimant the sum of 1.9 billion naira for settlement of the mature obligations on some time deposit, which was admitted by the second defendant, the claimant decided to set off his obligation to the second defendant under the TIA, the liability of the second defendant to it for the mature deposit it had settled. That following the set-off, the claimant commenced an action at the Federal High Court against the second defendant for the court to affirm the set-off to recover the outstanding amount due and owed by the second defendant to the claimant under a credit facility granted to the second defendant. While the court delivered judgment in favor of the claimant, the second defendant has appealed the said judgment. That prior to the set-off, the Federal High Court judgment, the second defendant and the claimant had commenced negotiations for the settlement of the staff liabilities in line with the TIA, and also subsequent to the judgment and strictly on humanitarian grounds, parties still continue with the negotiations for the settlement of the staff, and the claimant by its letter dated 16th of December 2020 agreed in principle that it should pay the staff obligations based on the claimant's computation of the amount, provided that the second defendant recognized the fact that in the event that the appeal in the Federal High Court case is decided in favor of the claimant, the amount paid will automatically be treated as an additional liability of the second defendant to the claimant, which the claimant will be entitled to recover from the second defendant. However, second defendant did not accept the caveat, and by its letter dated 20th/12/2020, insisted that the settlement should proceed without any reference to the existing judgment and ongoing appeal. But the claimant responded through its letter dated 8th of February 2021 and reiterated the fact that the existing judgment against the second defendant could not be ignored and required that the second defendant should acknowledge the fact that any payment made by the claimant pursuant to the settlement would be regarded as an additional obligation or by the second defendant to the claimant. And in the event that the appeal is decided in favor of the claimant will be entitled to recover the amount paid under the settlement from the second defendant. Conversely, if the appeal is decided against the claimant, the payment to be made under the settlement should be acknowledged by the second defendant as having fully satisfied the obligation of the claimant to pay outstanding staff liabilities under the TIA. That when the second defendant still refused to accept the caveat, the negotiations consequently broke down. Claimant stated that the first defendant continued to mount pressure on it, and by its letter dated 20th January 2021 and 16th February 2021, threatened to picket the claimant for an alleged failure of the claimant to proceed with the settlement. According to the claimant, any protest or congregation of members of the first defendant as protesters outside any of the claimant's business offices is bound to affect the claimant's operation, as well as have a damaging effect on the claimant and his customers. Now, the first defendant threat is intended to physically obstruct, injure, or intimidate or otherwise interfere with the claimant and his numerous customers. According to the claimant, shutting down the claimant's offices nationwide and causing a disruption of the claimant's businesses will lead to colossal financial losses and will put thousands of innocent customers in jeopardy. Case of the first defendant. Till the first defendant case from its pleading that until sometime in 2015, the claimant was the parent company of the second defendant and owned the majority shares in the second defendant, but the claimant and the second defendant terminated the ex-staff in order to reduce their workforce. To avert that, the claimant under the TIA undertook to unconditionally create a credit line for the purpose of settling all outstanding liabilities of the ex-staff of the second defendant, who happened to be the first defendant members. The purported sum of 1.9 billion allegedly paid to customers of the second defendants as mature deposit by the claimant went recoverable from the credit line. It's contended that neither the first defendant nor any of its members was a party to the case before the Federal High Court. First defendant further contended that its members are entitled to associate and assemble freely anywhere in the country. First defendant also stated that the claimant has failed to discharge its obligation under the TIA for redundancy benefits and other entitlements of its members, and unless it is forced to honor its obligation under the TIA, redundancy benefits and other entitlements of its members will remain perpetually unpaid. The members of the first defendant are law-abiding, civil, and peaceful citizens who are always desirous of pursuing their civil and constitutional rights. The first defendant has carried out similar picketing activities at various times without causing any threat or interference with the public or business activities. The first defendant has not threatened to shut down the claimant's head office or any of its business premises nationwide. According to the first defendant, it has the mandate to protect and advance the interests and rights of its members and affiliates, as well as to promote the general welfare of all Nigerian workers and citizens. It's also stated that not less than 47 of the members of the first defendant have died, leaving behind wives and children without receiving any of the benefits and entitlements due to them. That some of the ex-staff of the second defendant initiated an action against the second defendant and obtained judgment in this honorable court, affirming their rights to redundancy and other benefits. Case of the second defendant. According to the second defendant, the claimant undertook to provide a credit line for the second defendant solely for the purpose of settling outstanding liability of the second defendant's ex-staff, but the loan transaction between itself and the claimant has nothing to do with the payment of the terminal benefits of its ex-staff. However, it was the refusal of the claimant to provide the funds to be paid as terminal benefits of its ex-staff as contained in the TIA that caused the ex-staff to sue the second defendant at National Industrial Court. The refusal of the claimant to honor her obligation under the TIA has caused suffering, distress, and deaths of some members of the first defendant. The action of the claimant in setting up its obligation under the TIA with the second defendant's supposed indebtedness is in breach of the provisions of the TIA and to deny its innocent ex-staff their terminal benefits. The second defendant said that it did not have any negotiation with the claimant on the payment of its ex-staff, as her position is clear and predicated on the TIA. However, when the claimant was directly negotiating with the first defendant, the claimant made a proposal to make the payment conditional on the outcome of the appeal, which the claimant rejected. The second defendant also averred that in the process of amicable settlement of the matter, the claimant offered to provide the funds as contracted to the second defendant as a conditional loan, but the second defendant refused to sign the proposed memorandum of agreement because it sought to transform an outright unconditional grant to a conditional loan in clear breach of the terms of the transaction implementation agreement. That it was as a result of this that the first defendant planned to picket the claimant to compel her to provide the funds to pay the second defendant's ex-staff as contracted. Trial in this suit commenced on the 7th day of December 2021, where claimant's witness, CW1, testified by adopting his two statements on oath, let's say 18 June 2021 and 7th December 2021, and tendered the following documents as exhibit. Exhibit UBN1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14. CW was thereafter cross-examined by the first and second defendant, and as there was no re-examination, CW1 was discharged and the case of the claimant was closed. Defendants opened their defense on the 7th of the same 7th of December 2021, and the first defendant called 2 witnesses. Tolu Akimayowa testified as DW1 and returned his statement on all dated 6th October 2021. DW1 was discharged as there was no cross-examination. Mr. Akime Godwin, DW2, testified and returned his statement on oath dated 6th October 2021 and tendered 5 exhibits, which are as follows. Exhibit TUC1, TUC2, TUC3, TUC4, and TUC5. DW2 was discharged as there was no cross-examination, and the first defendant thereafter closed her case. The second defendant called Mrs. Chelufisi as DW2. She adopted her statement on oath on the 2nd of December to September 2021 and identified it with exhibit UBN 13. As there was no cross-examination, DW2 was discharged and the matter was adjourned for adoption of final written addresses. Second defendant final address. Second defendant final address, which was filed on 17th of January 2022, was deemed as properly filed and served on the 18th March 2022 via leave of court. The final written address contains 2 issues for determination to it. Number 1, whether the claimant is entitled to the reliefs sought. Number 2, whether the contact claimant is entitled to the reliefs sought. Another counsel submitted on issue 1 that the claimant is not entitled to the relief sought and is bound to fail as no legal right has been disclosed by the claimant. As the first defendant has a legal right to picket the claimant, and this right cannot be restrained by the claimant, citing Section 43 of the Trade Union Act and the case of Chevron Nigeria Limited and NUPEM. It was submitted that picketing action planned is lawful, justified, and warranted. The legal right of the first defendant cannot be restrained and is provided for and protected by law, referring to the case of Akapo and Hakim Habib. Counsel submitted on issue 2 that the contract claimant is entitled to the relief sought, that the provisions of the TIA places a mandatory obligation on the claimant to provide the credit line to the second defendant for the benefit of the members of the first defendant and to write off the credit in its entirety. That the said provision expressly created a trust of which the ex-staff of the second defendant are sole beneficiaries. That the trust fund credit is for the sole purpose of settling staff liabilities, which shall be written off entirely by the claimant. Going to the second defendant, the credit line is an express grant by the claimant to the second defendant to settle staff liabilities, and thus a grant becoming to the ex-staff and not and the grant, and thus a grant belonging to the ex-staff and not a loan to be refunded or repaid. That is straight law that parties are bound by their agreement they willingly entered into. That's in the case of Arta Industries Limited and Bank of Commerce and Industries, National Salt Company Nigeria Limited and Ines Palmer, KD Ventures Limited and Minister FCT. They submitted that while there's a contract, the court will intervene to protect the contractual right of the parties, such in the case of Thomas and Olufayese. Counsel of the court, based on the authority cited above, to interpret clause 9.2.4 of Exhibit UBN1 and enforce the terms contained therein and grant the relief sought in the counterclaim. It is submission of counsel that A critical examination of the relief sought in the judgment of the Federal High Court relied upon by the claimant will show that judgment did not erode the obligation of the claimant to provide the credit line to pay the staff liabilities. The judgment did not also erode or extinguish the right of the ex-staff to enforce the provisions of clause 9.2.4 of the TIA, which was made exclusively for the benefit of the ex-staff. The claimant is in breach of the provisions of clause 9.2.4 of the Exhibit UBN1 by setting off the entitlement of the second defendant's ex-staff to satisfy part of the debt owed by the second defendant. Counsel further submitted that the case before the Federal High Court was assessed on an undefended list, and it is clear from judgment that the court did not order the claimant to suspend her obligation to the ex-staff by setting up their entitlements. Counsel strongly believe that the Federal High Court's acknowledgement of the setup is not a ratification or affirmation of sin. That the setup was not an issue before the court, and the suit was a simple debt recovery action, not involving the owners of the setup fund, i.e., ex-staff. It was submitted that the claimant's sole witness acknowledged that the ex-staff were not indebted to the claimant, and that the setup was done before the suit was instituted at the Federal High Court. Another counsel submitted that the ex-staff who are represented by the counter-claimant can enforce the terms of the transaction implementation agreement because clause 9.2.4 was made solely and exclusively for the benefit of the ex-staff. That is trial law, it is trial law that the beneficiaries of the trust can enforce a trust that third parties for whose benefit a transaction was made could maintain a course of action to enforce the contract by themselves by joining the trustee to the promisor as defendants should the former refuse to discharge his obligation. Counsel contended that the above principle is an exception to the common law rule that a person who is not privy to a contract cannot enforce the terms of the contract, citing the case of Gregory and Parker versus Williams. First defendant written address. First defendant final written address filed on the 8th of February 2022 contains 3 issues for determination to it. Number 1, whether the claimant is entitled to the relief sought in the complaint and settlement of facts. Number 2, whether the claimant stroke defendant to the counterclaim is not unconditionally obligated to pay the gratuity, pensions, redundancy, and other terminal benefits and entitlement of ex-staff of the second defendant. Number 3, whether in view of the totality of the pleadings and evidence before this honorable court, the counterclaimant is also entitled to the relief sought in the counterclaim. It is the submission of counsel on issue 1 that the first defendant performs her function by engaging in legally recognized industrial action, which includes but not limited to picketing, strikes, and protests, among others. The claimant is seeking to obtain a perpetual injunction from this court to stop the first defendant from questioning or challenging the claimant's past, present, and future oppressive treatment of her staff and those of her subsidiaries. The perpetual injunction, if granted, would be antithetical to the law and best labor practices all over the world. Another counsel submitted that there's no evidence or record to support the assertion of the claimant that the first defendant has threatened to picket his offices nationwide. And the document upon which the claimant based her allegations was Exhibit 11, a letter purportedly written by the area commander Ogeli to the Ogeli branch manager of the claimant. But in the said letter, there is nothing to show that the first defendant threatened to picket the claimant's offices. To the counsel, there is also no evidence of the letter which the area commander purportedly responded to or record. But assuming without conceding that the first defendant threatened to picket or demonstrate outside the office of the claimant, it will still not be enough to run this honorable court to perpetually bar the first defendant from embarking on any industrial action against the claimant. To the submission of counsel that by virtue of Section 40 of the Constitution of the Federal Republic of Nigeria, every person has a right to peaceful assembly and association. Citing the case of IGP and ANPP and Eronini and Eronini, counsel first submitted that there is no evidence to justify the declaratory relief asked for by the claimant. The declaratory action cannot be successful even on the admission of the adversary or the weakness of the defense. Hence, the claimant bears the burden of proof to establish entitlement to declaratory reliefs to satisfaction of the court. Citing the case of Naipos and Musa, the submission of counsel that the claimant admitted at trial in Exhibit 1 that she undertook to create a credit line for the ex-staff of the second defendant. The claimant made this undertaking willingly and freely and went as far as undertaking to write up the same credit line, which means that it was not a debt that could be recovered, but suddenly made a reprobation after other parties had performed their obligation to appraise and deny the workers who had served the claimant through her subsidiary, second defendant, of the legitimate armed benefits. Counsel for us submitted that the heavy reliance by the claimant on the judgment of the Federal High Court is to mislead the court into legalizing the unjust act of the claimant. The state judgment, which is now subject to an appeal, was not against the first defendant or any of its members. Neither was the first defendant nor the ex-staff of the second defendant parties to the judgment. The ex-staff of the second defendant or beneficiaries of the credit line creating Exhibit UBN1, which was for the sole purpose of settling their earned benefits and entitlements. That they have not been paid their benefits and are entitled to demand same through every legal means from the claimant who is obligated to pay them. On the first and second, on the first defendant's issues 2 and 3 for determination, counsel sought to align his position with that of the second defendant under its issue 2 of his final address, and contended that the claimant had agreed with the counter-claimant that she was obligated to settle the staff liabilities of the second defendant as contained in clause 9.2.4 of the TIA. However, the claimant's only defense was that the benefits due from her to the second defendant have been set off against the purported debt of the second defendant. So the first defendant, the purported set-off was made in bad faith after the ex-staff demanded payment of their terminal benefits and entitlements. It was contended by counsel that the issue and claim before the Federal High Court was not to set off the purported debt with the self-terminal benefit, referring to Exhibit UBN 5. It's also the contention of the first defendant that the Federal High Court did not set off the benefits of the ex-staff, but simply granted an order for payment of the debt owed the claimant by the second defendant because the ex-staff who were beneficiaries of the unconditional grant created in Exhibit 1 were not parties to the suit. Citing the case of Alex, Courier Services, and Ugu. Claimant's final address. Claimant's final address filed on the 16th of March 2022 was deemed as properly filed and served via leave of court. Final address contains 2 issues for determination to it. While the claimant is entitled to the reliefs sought. Number 2, is the first defendant's counterclaim sustainable? The submission of a counsel on issue 1 that the claimant has on a holistic evaluation of the pleadings and evidence before this honorable court proved its claim and is entitled to the reliefs sought. At resolving the said issue 1, the following sub-issues need to be considered. Number one, whether the claimant has any legal obligation to pay the entitlement or benefit of the former employees of the second defendant. Number two, whether members of the first defendant can legally carry out picketing activities against the claimant based on the non-payment of the entitlements or benefit of the former employees of the second defendant. And number three, whether this honorable court should perpetually restrain the defendants from carrying out or engaging in any form of picketing activities against the claimant. The Honorable Counsel submitted in sub-issue 1 that this case clearly reveals that the foundation upon which the members of the first defendant had premised their decision, threat to picket the premises of the claimant is the perceived but erroneous belief that the claimant owes them a duty to pay their entitlements or benefits. It was submitted that upon proper appreciation of paragraph 9.2.4 of the TIA, the claimant does not owe any duty or obligation to pay the entitlement of the former employees of the second defendant. Counsel first submitted that the duty to pay employees' wages, entitlements, or benefits in any organization rests squarely on the employer. Therefore, where there is a breach of duty, the employees can only have recourse to the employer for redress. Counsel also submitted that the members of the first defendant are former employees of the second defendant, and thus, to the second defendant are the former employer who owes them a duty to settle their wages, entitlements, and benefits. That the breach of that duty must be remedied by the second defendant and not the claimant who was never an employer of members of the first defendant. His submission of counsel that the members of the first defendant recognize the above position, and that's why they rightly sued and got judgment against the second defendant in this court, which the claimant was never a party to the suit and cannot be bound by it. Counsel took the view that the TIA only created a duty on the claimant to make funds available to the second defendant to settle the liabilities of the former employees. But the TIA did not create an obligation on the claimant to pay members of the first defendant. Counsel considered that assuming the provisions of paragraph 9.2.4 of the TIA created an obligation on the claimant to pay the entitlement of the members of the first defendant, that obligation no longer exists as it has been legally set off by the bank and affirmed by the Federal High Court. And the counsel further contended that before the execution of the TIA, the claimant and the second defendant owed each other mutual financial obligations. A second defendant was indebted to the claimant on the mature timeline, on a mature time deposit to the tune of 1.4 billion naira. On the other hand, the claimant was also financially obligated on the TIA to create a credit line for the second defendant. This evidence was not challenged or contradicted by the defendant, and the law is tried that an unchallenged evidence stands and can be acted upon by the court. Citing the case of Onyora and Onyora. Ghana Council submitted that on issue 2, the claimant is not under any legal or contractual duty to pay the entitlements of the members of the first defendant. That under Section 42 of the Trade Union Act, picketing cannot be carried out against a person or company who is not the employer or who does not owe the picketing persons or group any contractual duties or obligations. That's in the case of Chevron Nigeria Limited and Peng. Submitting further, counsel argued that picketing is only justified when the picketing workers work for the organization against whom the picketing is directed. However, in the instance case, the unchallenged evidence is that members of the first defendant never worked for the claimant. There was no contractual relationship between them. Therefore, the picket is improper and illegal and should be restrained by the court. Council also argue on sub 3 that it is strict law that where a party in a suit has established a legal right for their protection, the court is entitled to grant a perpetual injunction to protect such right from being infringed after it had heard the case of the claimant on the merit. But in the case of Ojo and Akinsanoye, Mohammed and Abubakar, so it was submission of the learned counsel for the claimant that the contract claimant has no local standard to sue to enforce the terms of the TIA. The law is now settled beyond question that where a cause of action is premised upon a contract, the only persons competent to enforce such contract or seek remedy for any breach of the contract are the parties to the contract. But it's elementary that a person who is not a party to a contract cannot legally sue to enforce the terms of the contract or seek relief for any alleged breach of the contract. So in the case of NNPC and ALC, Woman Line and BM Limited, the first defendant is not a party to the TIA and it cannot sue or be sued on it and does not have any local standard to enforce the terms or seek any remedy for an alleged breach of the contract. It is only second defendant that can enforce the terms of the TIA against the claimant. First defendant reply on to the claimant's written address. First defendant filed a reply on points of law to the claimant's final written address on the 5th of March 2022, where counsel for the first defendant reasserts and put forward the argument that its members, that it is its members that have the right to picket the claimant and that it has the local standard to enforce the undertaking made by the claimant under exhibits UBN1. Such in the case of Jolugbo and Aina and CMB Building Maintenance and Investment Company and Aboladi. This is my opinion. Upon careful perusal of the pleadings of the parties, the evidence presented, and submission of the respective counsel, I know that the parties have raised their respective identical issues for determination along with some sub-issues. But to me, the two issues raised by the second defendant are simpler and more direct to the point. The said issues are, number one, where the claimant is entitled to the reliefs sought. Number two, where the contract claimant is entitled to the reliefs sought. The claimant has asked for a declaration that the picketing action or any other industrial action planned, intended, or threatened against it by the first defendant or any persons acting on its instruction is unlawful, unjustified, and unwarranted, and consequently asked for a perpetual injunction to send the defendants or any of its agents or previous from carrying out any picketing or labor activities against the claimant. Picketing is defined as, and I quote, the presence at an employee's business of one or more employees and or other persons who are publicizing a labor dispute, influencing employees or customers to withhold their work or business respectively, or showing a union's desire to represent employees. Picketing is usually accompanied by patrolling with signs. See Wikipedia. Picketing derives its statutory recognition from Section 43, sub 1 and 2 of the Trade Union Act, which provides as follows, and I quote, it shall be lawful for one or more persons acting on their behalf or on behalf of the trade union or registered federation of trade unions of an individual employer or firm in contemplation of furtherance of the trade dispute to attend at or near a house or place where a person resides or works, carries on business, or happens to be. if they so attend merely for the purpose of peaceful obtaining or communicating information, or of peaceful persuading any person to work or abstain from working. Sub 2, accordingly, the doing of anything declared by subsection 1 of this section to be lawful shall not constitute any offense under any law enforced in Nigeria or any part thereof, and in particular shall not constitute an offense under section 366 of the Criminal Code or any corresponding enactment enforced in any part of Nigeria, unquote. Similarly, too, I think section 40 of the Constitution of Federal Republic of Nigeria as amended has also thrown its weight behind the provisions of section 43 of the Trade Dispute Union Act. It provides thus, and I quote, every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interests, unquote. It was held in Eronini and Eronini that every person resident in Nigeria has a right to go about his or her lawful business unmolested or unhampered by anyone else, be it a government functionary or a private individual. See the case of Npa and Nkwame. It appears from the above that the right to peaceful picketing, as recognized under Section 40 of the Trade Union Act, and which derives its basis from Section 40 of the National Constitution as amended, seems to be lawful if done in a peaceful manner, and for the claimant to ask for the court's intervention, he has to justify that his rights have been stepped upon. It's the case of Motorcycle Transport Union of Nigeria and Delta State Motorcyclist Association. It can be observed from subsection 2 of section 43 that once the picketing activities are done in a lawful and peaceful manner, then that action shall not constitute any offense under any law enforced in Nigeria or any part thereof. It now remains to ask whether declaration can be granted to make a lawful act of picketing or lawful, unjustified, and or unwarranted without a claimant justifying same in his pleadings, considering the elementary law that declaratory reliefs cannot be granted just for the asking. It is tried that declaratory reliefs must be strictly pleaded and proved by credible evidence, which has to be led and proffered by the claimant to the suspicion and discretion of the court. In other words, in a declaration, the claimant must call evidence that will satisfy the court to make the declaration sought. Declarations are equitable reliefs, and so the party seeking such must present the materials upon which the court will act to so declare. That's why admissions in pleadings cannot be the basis for declaratory reliefs. See the case of Akande and Adisa, AG Cross River State and AG Federation, Obasanjo and Buhari, Omishore and Arebeshola. Claimant had contended that it has established evidence that it has legal right to carry on business in Nigeria without any interruption, and is not contractually obligated to the members of the first defendant in any way. But more importantly is the fact that the first defendant has shown by exhibit UBN 14 that its members will carry out picketing activities against the claimant. However, the first defendant, claimant is obligated under exhibit UBN 1 to settle the outstanding staff liabilities of the second defendant, but that the claimant has failed to discharge its obligations, the TIA for redundancy and other entitlements of its members, and unless it is forced to honor its obligations under the TIA, the redundancy benefits and other entitlements of its members would remain perpetually unpaid. It is the failure of the claimant to so honor exhibit UBN 1 that prompted the ban of the picketing activities as justified under Section 43 of the Trade Union Act. I need to underscore the point that even though Section 40 of the National Constitution has guaranteed the right of every person to assemble and associate freely with others and to form or belong to a political party, trade union, or other association for the protection of its interests, but it admits of some exceptions. In other words, it's not absolute. However, I've not been able to see any evidence provided by the claimant that the first defendant's right to peaceful picketing should be curtailed. The fact that the claimant is a registered entity licensed to carry on banking business in Nigeria not mean that the first defendant cannot carry out picketing activities against it, more especially that the first defendant rely on the undertaking made by the claimant under clause 9.2.4 of Exhibit UBN1 that the claimant shall create a credit line for the second defendant, which shall be applied solely for the purpose of the second defendant's staff liability, which shall be subsequently written off. See Executive Chairman and Management of Benue State and Subeb, Registrar of Trade Unions and Osawe, ASCO Investment Limited, and EZI. Let me refer to paragraphs 4, 5, and let me refer to paragraphs 3, 4, and 5 of the UBN 14, which is stated as follows, and I quote: "Please take note that it is our belief that Union Bank has obligation to pay this money by its own endorsed TIA. The payment needs not be attached to any other condition. Will not be drawn into internal politics between Union Bank and Union Homes. We are tired of these delay tactics. We therefore give you 2 weeks for Union Bank to perform its obligation. Failing, sir, we shall give no further notice when we shall engage the organization nationwide on a full-scale industrial action with highest regards," unquote. Based on the foregoing, I think the first defendant is entitled to praise some their demand for the payment of the entitlement of their members. I believe there's still wrong with them planning to embark on industrial action against the claimant or any person, as long as their action is within the orbit of the law. See the case of Chevron Nigeria Limited, National Union of Petroleum and National Natural Gas Workers, NUPEM. Accordingly, I hold the view that the claimant case is not one deserving the grant of declaratory reliefs and perpetual injunction against the defendant. The case fails and is accordingly dismissed.
As the court pleases.
Turning to the counterclaim. Counterclaimant asks for a declaration that the defendant to counterclaim is unconditionally obligated to pay all outstanding staff liability of the second defendant by virtue of the TIA, and an order directing the defendant to counterclaim to pay all the outstanding staff liability of the second defendant, including gratuity, pensions, redundancy benefits, and other terminal benefits and entitlement. The defense of the defendant to the counterclaim is that its obligation under TIA was owed to the second defendant and not the counterclaimant, and that the counterclaimant and its members were not previous to the TIA, hence lack local standard to enforce the terms. From the brief fact of the case of the parties as contained in their pleadings and documents presented, second defendant was a subsidiary of the claimant, and by Exhibit UBN1, the claimant transferred her shares in the second defendant to ASO Savings and Loans, PLC. That in clause 9.2.4, it was provided as follows, and I quote: "Union Bank shall, for the purpose of the UHSL, settling outstanding staff liabilities, create credit line for UHSL, which shall be applied solely for the purpose of staff liabilities, provided that the credit line shall be subsequently written off entirely by UBN," unquote. That the claimant did not create the credit line as stated above, but claimed that it had set off her obligation in Exhibit UBN1 with the indebtedness of the second defendant to the claimant, and that the setup was affirmed by the Federal High Court. As a result of negotiations by the parties, the claimant offered to provide the funds as contracted in UBN1 as conditional loan, but the offer was rejected by the second defendant. Following which, the first defendant planned to picket the claimant to compel her to provide the funds meant to pay the second defendant's ex-staff. There's no dispute that the claimant struck defendant to the counterclaim had agreed in Exhibit UBN1 that she would create credit line for the sole purpose of settling the entitlement of the second defendant ex-staff. But the only issue is that since the second defendant was indebted to the claimant, then the claimant set off her obligation under the TIA and went to the Federal High Court to recognize the set-off and now only agreed to provide the funds as conditional loan. In law, once parties of their own free will and volition enter into a written agreement, they should in law be bound to honor and be bound by the terms of their agreement. And therefore, the relationship and subsequent disagreement must be resolved with their agreement and the court cannot go outside the terms as agreed upon by the parties. It was held in Ahmed and CBN that parties are bound by the terms of their contract, and the court cannot read into such contract what is not within the contemplation of the party, except where fraud, duress, or misrepresentation are established. It is instructive to add that the terms of contract between the parties are closed with some degree of sanctity, and if any question should arise with regards to the contract, the terms in any document which constitute the contract are arguably the guide to its interpretation. It's not within the purview of the court to write a contract for the parties. See Minaj Holdings Limited and AMCON. The court, therefore, in determining whether there has been a breach of the contract, are enjoined to confine themselves to the plain words and meaning derived from the document. This is the case of Oyamande and Abraman. The provisions of clause 9.2.4 of Exhibit 1 are straightforward, and the law with regards to the interpretation of clear and unambiguous content of a document is so commonplace. It was said by Supreme Court in the case of Nigerian Army and General Aminu Kano that, and I quote, "Nothing is more unfortunate than a disturbance of the plain language of the legislature by the attempt to equivalent term. As no court will attempt to interpret or construe an act of parliament contrary to the express words of the act. It's in my view that the attempt made by the claimant to set up an obligation under the clear and unambiguous provision of the Exhibit UBN with the indebtedness of the second defendant to her is a clear breach of the provisions of the UBN. I think it does not look neat for the claimant to set off the funds made for the ex-staff of the second defendant just because the second defendant was indebted to her. I think the claimant only wanted to play smart by going to the Federal High Court to recognize the setup. The point I want to say is that if the claimant will be allowed to set up the funds made for the ex-staff of the second defendant against the interpretation of the second defendant, then it means the whole of Exhibit UBN1 can be made rubbish. The claimant should not be allowed to eat its cake and have it. You cannot appropriate and reprobate or blow hot and cold from the same breath by undertaking to provide funds for the benefit of the members of the counter claimant and take away the funds with another hand. I think the law should not allow that. It's really unconscionable for the claimant to play smart, to circumvent its obligation under the TIA to attach any conditions to the grant it undertook to provide for the benefit of the second defendant's ex-staff. By Section 169 of the Evidence Act, when one person has either by virtue of an existing court judgment, deed, or agreement, or by his declaration, act, or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative in interest shall be allowed in any proceeding between himself and such person or such person's representative in interest to deny the truth of that thing. Payment of salaries or wages and entitlement is the right of a worker who has earned it. In the case of Uday and Federal Capital Development Authority, the Supreme Court held that a worker is entitled to wages that are earned, and this right is automatically implied in the contract of employment. It is therefore the right of the claimants to be paid their benefit for the work done, and such right cannot be taken away for no just cause. Both the claimant and the first defendant refer to the case of EDEX, Korea Services Limited and Ugu, on reduction of privity of contract. It was stated in that case that generally third parties to a contract cannot sue or be sued on it. But a third party beneficiary may legally enforce the contract only after his or her legal rights have already been vested, either by the assent of the contracting parties or by justifiable reliance on the promise. For a third party beneficiary to enforce a contract, his right under the agreement must have vested, which means that the right must have come into existence. Before the third party beneficiary's right vests, the original parties to a contract can modify their contract in any way they see fit. Once right vests, the original parties cannot discharge or modify contractual right without the beneficiary's agreement to a change to the contractual rights. In the instance case, the first defendant members are intended third-party creditor beneficiary in the agreement between the claimant and the third and the second defendant. As such, the claimant cannot alter the agreement to the detriment of the members of the first defendant outside the provision of the ITA. Having the first defendant rely on the promise made by the claimant to provide the funds for the ex-staff of the second defendant. In paragraph 2 of Exhibit 10, that was addressed to the claimant, the first defendant stated thus, and I quote, "It will be recalled that the meeting of 10th December 2020, attended by all stakeholders on this issue, it was the understanding that your bank will pay off the ex-workers' entitlement without any conditions." Unquote. The above are find and hold that the members of the first defendant as third-party beneficiaries are more than a mere outsiders to a contractual agreement made by the claimant to pay their entitlements. Therefore, they are legally protected with right to enforce the agreement to which they are a beneficiary. See also clauses 7.2.2, 11.2.3, 11.2.4, 11.2.5, 11.2.6 of Exhibit UB and 1. On the whole, and for the reasons given, the claimant's case fails. It lacks merit and is accordingly dismissed. Meanwhile, the defendant's counterclaim succeeds and it's as follows. Declaration that by virtue of clause 9.2.4 of the TIA, dated at 1st December 2013, the claimant/defendant to counterclaim is unconditionally obligated to pay all outstanding staff liability of the second defendant. Number 2, an order of this honorable court directing the claimant/defendant to counterclaim to pay all outstanding staff liability of the second defendant, including gratuity, pensions, redundancy benefits, and other terminal benefits, and entitlement in line with Exhibit UBN1 and the defendant's staff policy guideline of 2017 Exhibit TUC2. Judgment is entered accordingly with no order as to cause.
As the court pleases.
As the court pleases.
Thank you, my lord. I have listened attentively to your judgment.
Yes.
And I must say, with due respect, my lord,
Yes.
that we have been educated.
No problem, no problem.
We have been educated. And I believe that it is all about justice.
Yes.
So
yes.
we will proceed in line with what my lord has said. And if it is necessary to go on appeal, we probably will want to test the principles that my lord has given to us. So I am really very, very happy. And my lord, sir, I think I will be following your judgments going forward.
Thank you so much, Prof. I thank you so much. I appreciate that. I appreciate that. I also appreciate the industry put in your written address, especially the issue of resultant trust, implied trust. I had wanted to follow that path, but having seen your argument in that, I just declined not to follow the issue of that trust as an exception to the doctrine of privity.
Yes.
But the way you have pushed the case cited by Mr. Abdullah,
yeah.
I just say I shouldn't follow that path.
Yes, sir. Yeah, but sincerely, sir, it's all about the people, the ex-employees.
Yes.
Yes, we need to do something about it.
Actually.
Because if the claimant and the second defendant have actually sorted out this issue, we won't be where we are, sir.
Yes, it wouldn't be where we are.
Yeah.
Yes.
That's the issue. So I am very grateful to you, sir, and thank you that there is no other as to cost. I will.
Yes. No other as to cost.
God bless you.
Thank you so much. Yes. So Abdul.
My Lord, we are very grateful for the well-considered judgment of your Lordship. We have also learned a lot, and I've also learned from Prof too in their written address, and he shows he's our teacher.
Yes.
However, we are very grateful, and I believe some of the staff of the concerned in this matter are actually watching, and I believe that they are also grateful to there's our members. They are also grateful for the work. We hope that Prof will advise the people to quickly discharge themselves of all obligations this matter. We are most grateful.
Thank you, Abdullah. Mr. Odum, are you with us?
Yes, I'm here, my Lord. We are very, very grateful for the sense of justice behind the judgment. And I also thank my planet friend, the prof. Incidentally, he taught me at the university, so I only applied what he taught me to do. That he taught me well. And I'm grateful to my Lord. I'm also grateful to my learned colleagues as well, my learned friends. We are grateful.
It's okay. Thank you so much. So, learned Prof.
Yes, sir.
That will be all for today. I thank you so much.
Yes, thank you, sir.
It's okay, Mr. Oduman Abdullah.
Thank you, sir.
Yes, I should say bye for now. Yes.
Bye, sir.
It's okay. Thank you so much.
Yes.
And good afternoon. Yes.
Bye-bye. Thank you, Jesus. One Lord.
Congratulations.
Odum.
Prof, thank you, sir.
Let us have a meeting.
All right, sir. All right, sir.
Odum, Abdullah, let's have a meeting. You tell me when you want us to have the meeting. To be honest with you, the justice of this case is about the ex-staff, in all honesty. So, picketing won't solve the problem. I think what will solve the problem is getting money into the accounts. All right?
Very well.
I believe that this can be sorted out by His grace. Okay? Is Odum there? Odum's data has disappeared.
I think he has left.
Okay, so we talk. Abdullah, please call me.
All right, sir. All right, sir. I'll do that.
All right. God bless you.
You too.
Bye.
Bye, sir.
Congratulations, sir.